Hello, this is R.J. Deacon reading the Supreme Court of the United States per curiam opinion in Sexton versus Beaudreaux on petition for the writ of certiorari to the United States Court of Appeals for the Ninth Circuit, decided June 28, 2018. Again, per curiam opinion, no syllabus. In this case, the United States Court of Appeals for the Ninth Circuit reversed a denial of federal habeas relief on the ground that the state court had unreasonably rejected respondents' claim of ineffective assistance of counsel. The Court of Appeals decision ignored well-established principles. It did not consider reasonable grounds that could have supported the state court's summary decision, and it analyzed respondents' arguments without any meaningful deference to the state court. Accordingly, the petition for certiorari is granted, and the judgment of the Court of Appeals is reversed. Respondent Nicholas Beaudreaux shot and killed Wayne Drummond during a late-night argument in 2006. Deo Esho and Brandon Crowder were both witnesses to the shooting. The next day, Crowder told the police that he knew the shooter from middle school, but did not know the shooter's name. Esho described the shooter, but also did not know his name. 17 months later, Crowder was arrested for an unrelated crime. While Crowder was in custody, police showed him a middle school yearbook with Beaudreaux's picture, as well as a photo lineup including Beaudreaux. Crowder identified Beaudreaux as the shooter in the Drummond murder. Officers interviewed Esho the next day. They first spoke with him during his lunch break. They showed him a display that included a recent picture of Beaudreaux and pictures of 5 other men. Esho tentatively identified Beaudreaux as the shooter, saying his picture was closest to the gunman. Later that day, one of the officers found another photograph of Beaudreaux that was taken closer to the date of the shooting. Beaudreaux looked different in the 2 photographs. In the first, his face was a little wider and his head was a little higher. Between 4 and 6 hours after the first interview, the officers returned to show Esho a second 6-man photo lineup, which contained the older picture of Beaudreaux. Beaudreaux's photo was in a different position in the lineup than it had been in the first one. Esho again identified Beaudreaux as the shooter, telling officers the second picture was very close. But he, again, declined to positively state that Beaudreaux was the shooter. Esho was hesitant because there were a few things he remembered about the shooter that would require seeing him in person. At a preliminary hearing, Esho identified Beaudreaux as the shooter. At trial, Esho explained that it clicked when he saw Beaudreaux in person, based on the way that he walked. After seeing him in person, Esho was sure that Beaudreaux was the shooter. At no time did any investigator or prosecutor suggest to Esho that Beaudreaux was the one who shot Drummond. Beaudreaux was tried in 2009 for first-degree murder and attempted second-degree robbery. Esho and Crowder both testified against Beaudreaux, and both identified him as Drummond's shooter. The jury found Beaudreaux guilty, and the trial court sentenced him to a term of 50 years to life. Beaudreaux's conviction was affirmed on direct appeal, and his first state habeas petition was denied. In 2013, Beaudreaux filed a second state habeas petition. He claimed, among other things, that his trial attorney was ineffective for failing to file a motion to suppress Esho's identification testimony. The California Court of Appeal summarily denied the petition, and the California Supreme Court denied review. Petitioner then filed a federal habeas petition, which the district court denied. A divided panel of the Ninth Circuit reversed. The panel majority spent most of its opinion conducting a de novo analysis of the merits of the would-be suppression motion, relying in part on arguments and theories that Beaudreaux had not presented to the state court in his second state habeas petition. It first determined that the counsel's failure to file the suppression motion constituted deficient performance. The circumstances surrounding Esho's pretrial identification were unduly suggestive, according to the Ninth Circuit, because only Beaudreaux's picture was in both photo lineups. And relying on Ninth Circuit precedent, The panel majority found that the preliminary hearing was unduly suggestive as well. Quoting Johnson versus Sublett, the panel majority next concluded that under the totality of the circumstances, Escho's identification was not reliable enough to overcome the suggestiveness of the procedures. The panel majority then determined that counsel's failure to file the suppression motion prejudiced Beaudreaux, given the weakness of the state's case. After conducting this de novo analysis of Beaudreaux's ineffectiveness claim, the panel majority asserted that the state court's denial of this claim was not just wrong, but objectively unreasonable under 2254D. Judge Gould dissented. He argued that the state court could have reasonably concluded that Beaudreaux had failed to prove prejudice. The state of California petitioned for certiorari. Under the Anti-Terrorism and Effective Death Penalty Act of 1996, a federal court cannot grant habeas relief with respect to any claim that was adjudicated on the merits in state court proceedings unless adjudication of the claim resulted in a decision that was contrary to or involved in unreasonable application of clearly established federal law, as determined by this court, or a decision that was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding, 2254D. When, as here, there is no reasoned state court decision on the merits, the federal court must determine what arguments or theories could have supported the state court's decision, and then it must ask whether it is possible fair-minded jurists could disagree that those arguments or theories are inconsistent with the holding in a prior decision of this court. Harrington versus Richter. If such disagreement is possible, then the petitioner's claim must be denied. We have often emphasized that this standard is difficult to meet because it was meant to be. Burt versus Tiltlow. The Ninth Circuit failed to properly apply this standard. To prove ineffective assistance of counsel, a petitioner must demonstrate both deficient performance and prejudice. Strickland. The state court's denial of relief in this case was not an unreasonable application of Strickland. A fair-minded jurist could conclude that counsel's performance was not deficient because counsel reasonably could have determined that the motion to suppress would have failed. See Primo versus Moore. This court has previously described the approach appropriately used to determine whether the Due Process Clause requires suppression of an eyewitness identification tainted by police arrangement, Perry versus New Hampshire. In particular, the court has said that due process concerns arise only when law enforcement officers used an identification procedure that is both suggestive and unnecessary. Citing Manson versus Braithwaite and Neal versus Biggers. To be impermissibly suggestive, the procedure must give rise to a very substantial likelihood of irreparable misidentification. Quoting Simmons versus United States. It is not enough that the procedure may have in some respects fallen short of the ideal. Even when an unnecessary suggestive procedure was used, suppression of the resulting identification is not the inevitable consequence. Perry. Instead, the Due Process Clause requires courts to assess on a case-by-case basis whether improper police conduct created a substantial likelihood of misidentification. Biggers. Reliability of the eyewitness identification is the linchpin of that evaluation. Perry. The factors affecting reliability include the opportunity of the witness to view the criminal at the time of the crime, the witness's degree of attention to the accuracy of his prior description of the criminal, the level of certainty demonstrated at the confrontation, and the time between the crime and the confrontation. This court has held that pre-trial identification procedures violated the Due Process Clause only once in Foster versus California. There, the police used two highly suggestive lineups, and one-to-one confrontation, which made it all but inevitable that the witness would identify the defendant. In this case, there is at least one theory that could have led a fair-minded jurist to conclude that the suppression motion would have failed. See Richter. The state court could have reasonably concluded that Beaudreaux failed to prove that, under the totality of the circumstances, the identification was not reliable. Biggers. Beaudreaux's claim was facially deficient because his state habeas petition failed to even address this requirement, and the state court could have reasonably concluded that the totality of the circumstances tipped against Beaudreaux. True, Esho gave a vague initial description of the shooter. See Manson. Noting the detailed physical description the witness gave minutes after, and there was a 17-month delay between the shooting and the identification. See Biggers. Determining that a lapse of 7 months would be a seriously negative factor in most cases. That's Biggers again. But, as the district court found, Esho had a good opportunity to view the shooter. Having talked to Beaudreaux immediately after the shooting, he also was paying attention during the crime and even remembered Beaudreaux's distinctive walk. Esho demonstrated a high overall level of certainty in his identification. He chose Beaudreaux's picture in both photo lineups, and he was sure about his identification once he saw Beaudreaux in person. There also was little pressure on Esho to make a particular identification. See Manson. It would not have been objectively unreasonably to the way the totality of the circumstances against Beaudreaux, White versus Woodall. The Ninth Circuit's opinion was not just wrong, it also committed fundamental errors that this court has repeatedly admonished courts to avoid. First, the Ninth Circuit effectively inverted the rule established in Richter. Instead of considering the arguments or theories that could have supported the state court's summary decision, the Ninth Circuit considered the arguments against the state court's decision that Beaudreaux never even made in his state habeas petition. Additionally, the Ninth Circuit failed to assess Beaudreaux's ineffectiveness claim with the appropriate amount of deference. The Ninth Circuit essentially evaluates the merits de novo, only tacking on a perfunctory statement at the end of its analysis asserting that the state court's decision was unreasonable. But deference to the state court should have been near its apex in this case, which involves a Strickland claim based on a motion that turns on general, fact-driven standards, such as suggestiveness and reliability. The Ninth Circuit's analysis did not follow this court's repeated holding that the more general the rule, the more leeway state courts have. Renico versus Lett. Nor did it follow this court's precedents stating that because the Strickland standard is a general standard, a state court has even more latitude to reasonably determine that a defendant has not satisfied that standard. Knowles versus Mirzaeans. The Ninth Circuit's essentially de novo analysis disregarded this deferential standard. The petition for writ of certiorari and respondent's motion to proceed in forma pauperis are granted. The judgment of the United States Court of Appeals for the Ninth Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Breyer dissents. Thank you for listening. If you'd like to join a discussion about this or any of the other recent Supreme Court decisions, please find us at facebook.com/SCOTUSSLIP.